One of the biggest issues surrounding the U.S. Supreme Court today pertains to the issue of federalism. When should the federal government be permitted to legally control what happens in states such as Ohio, Wisconsin, New York, or Texas? When should states be able to control what happens within their borders? The judiciary's role in deciding federalism cases is a closely watched and controversial topic. As we will examine in this presentation, federalism rulings cannot be understood solely as simple conflicts of power between federal and state governments. The political ideology of judges who decide these cases may also play a role. In the book, The U.S. Supreme Court and New Federalism, Christopher Banks and John Blakeman point to the federalism revolution that occurred in the Rehnquist court between 1986 to 2005. William H. Rehnquist, who was nominated to the court by President Nixon, first established himself as a staunch conservative justice by frequently being the only justice to dissent on the politically moderate Burger Court. Over time, Rehnquist gained a reputation as being a champion of states' rights, and in 1986 he was promoted to Chief Justice by President Ronald Reagan. William Rehnquist gained a reputation for boldly curtailing Congress's power. In fact, during his tenure as Supreme Court Justice, the court invalidated 41 federal statutes. This is an unprecedented number. As Chief Justice, Rehnquist became more influential. He found allies in conservative justices such as Sandra Day O'Connor and Antoine Scalia, Anthony Kennedy, and Clarence Thomas. The Rehnquist court gained a reputation for boldly curtailing Congress's power under the Commerce Clause and the 10th Amendment. At the same time, the conservative Rehnquist court revitalized the 11th Amendment in order to limit federal judicial power. Rehnquist and his fellow conservative justices have been referred to by scholars as the Federalism Five. They orchestrated a new federalism and launched an assault on national power. Usually these were 5-4 decisions with very vigorous dissents. 21st century progressive federalism politics are nothing new. In fact, this struggle for power by states' rights goes back to the long-standing political debate that emerged at the nation's founding between Federalists and Antifederalists. Federalists, of course, were nationalists who wanted to have a strong, centralized government. On the other hand, Anti-Federalists were localists who were states' rights advocates. The election of President Barack Obama in 2008 certainly sent shockwaves through the Republican Party. Republicans were leery of the fact that President Obama favored proactive federal solutions. As a result, the ultra-conservative Tea Party emerged. For Tea Partiers, Obama's Health Care Act in particular represented a dangerous encroachment by the federal government into areas of policy that was traditionally governed by local citizens and their elected state leaders. Before the election of President Obama, Presidents Nixon, Ronald Reagan, and even Bill Clinton expressed commitments to increasing state autonomy while scaling back the federal government's reach over the states. However, events such as the September 11th attacks, the Iraq and Afghanistan wars, and Hurricane Katrina allowed President George W. Bush to centralize executive power and continue to make the general drift of authority to Washington, D.C. And when President Obama was elected, the Wall Street meltdown, coupled with bailouts of the automobile industry, the BP oil spill in the Gulf of Mexico, all of these led to a strong centralized federal government. In June of 2012, the U.S. Supreme Court had an opportunity to strike down President Obama's Patient Protection and Affordable Care Act, also known as Obamacare. But, as we know, the court did not do this. Ironically, the 5-4 decision was written by Chief Justice Roberts, who is considered to be one of the conservative justices on the court. This prompted many scholars to ask the question, why in the world would a conservative justice who seemed to favor states' rights vote in a manner which would greatly expand the power of the federal government? Before the late 1930s, the lines of authority between the federal and state governments were strictly drawn and enforced by the courts. However, when the Great Depression occurred, policymakers saw a need to enlarge the scope of federal power. New Deal legislation passed under President Franklin D. Roosevelt would greatly expand the federal government. The Social Security Act of 1935 was also devised by Congress to supply pension benefits and unemployment compensation to elderly and out-of-work citizens. This was, of course, financed by a federal tax. Even though today virtually everyone supports Social Security, this almost did not come to fruition. The Supreme Court in 1937 affirmed the Social Security Act in a 5-4 ruling. World War II would also expand the authority of the federal government, and once the liberal Warren Court emerged in the 1950s, decisions would be handed down which would increase the federal government's commitment to enforce civil rights. Eventually, the liberal Warren Court was replaced by the moderately conservative Burger Court, followed by the Rehnquist Court, which was even more conservative. The Rehnquist Court would render many decisions which would favor states' rights as well as limited national government. But today, in the post-9/11 era, and against the backdrop of the policies of the Obama administration, we are seeing a return to a strong central government. Also, President Obama nominated and was able to appoint 2 U.S. Supreme Court justices, Sonia Sotomayor and Elena Kagan, both of whom are quite liberal. After seeing the court affirm Obamacare, it is likely that we will continue to see a strongly centralized federal government. What is interesting also is that some of the states are engaging in acts of blue state federalism. Blue state federalism occurs when states legislate progressive social policy that has been traditionally ignored by the federal government. For example, today states are taking the lead in advancing gay and lesbian rights, environmental control, as well as banking regulation. At one time, it was the federal government which mainly provided progressive legislation and broke new ground. But in today's political climate, the states themselves are breaking new ground in this progressive manner. This again is referred to as blue state federalism. Today, the issue of states' rights versus a strong centralized government certainly comes up, and this is especially true during major elections. But it is probably safe to say that both Republicans and Democrats can agree on certain areas where there should be a strong national sovereignty. Can you imagine what life must have been like living under the Articles of Confederation before the first Constitutional Convention? For example, what if each state printed its own type of money? And suppose the governors of each of the 50 states negotiated with leaders in neighboring countries. This would be nothing short of an absolute mess. The economy would be completely dysfunctional, and the national sovereignty would be at risk. It's worth pointing out that immediately after the Revolutionary War, the United States was extremely decentralized. Americans had just won the hard-fought war for independence from Great Britain. However, after the war, Americans were extremely fearful of a strongly centralized government. So, for a short time after the war, there was no power to coerce the states into compliance on issues affecting the national interest. This type of system, which was extremely decentralized, simply cannot work in the long term. Fortunately, the Founding Fathers realized this and agreed that there should be a court of last resort. And, as we know from history, the 1789 Judiciary Act helped to establish this. But we also know that this did not come easy. Passing this act required an enormous amount of political maneuvering and compromise. Throughout the early republic, the Supreme Court did what it could to encourage federal expansion by granting Congress broad regulatory powers while limiting state interference. Ultimately, a nation-centered theory of federalism would prevail, but again, this would not come easily. For example, we know that the United States went through a brutal civil war. In many respects, this was over the issue of slavery, which represented a struggle between the will of the federal government and states' rights. Fortunately, the federal government won, but when you really think about it, it is nothing short of a miracle the way the country was able to come together in the aftermath of a brutal war, which would kill more than 600,000 Americans. Let's now jump about 100 years from the close of the Civil War to when President Nixon came to the White House in 1969. Nixon wanted to limit the scope of the federal government. He conceded that the federal government needed to oversee monetary policy and foreign affairs, as well as other areas such as raising revenues, borrowing money, or mailing out Social Security checks. But Nixon and his supporters wanted a new federalism which would permit ordinary citizens to regain control over government through a new order of national localism. Conceptually, at least, in the Nixon formulation, new federalism would respect certain realities of centralization while simultaneously honoring the citizens' basic choice to administer local affairs without federal interference. Today, this argument still resonates with the public, some sections of the public. For example, the Tea Party movement, which has provided the Republican Party with a tremendous amount of momentum, calls for a return to states' rights. And as we shall discuss throughout the next few weeks, the Rehnquist court between 1986 to 2005 rendered decisions which reflected the new Federalist ideology. Rehnquist and other conservative justices on the U.S. Supreme Court feared that the federal government was spiraling out of control and unduly trampling states' rights. As you begin the book, The U.S. Supreme Court in New Federalism, consider the role that the court should play. Should the justices step in and use the principles of new federalism to safeguard states' rights by imposing limits on congressional or judicial power? As we shall see next week, under the leadership of Chief Justice William H. Rehnquist, the court would hand down a series of new federalism decisions that would reflect a culture of restraint and conservatism. Next week, we will begin to explore the Rehnquist court, new federalism, and states' rights as we continue along the journey of examining issues related to the American judiciary.